Okay, we're live. Welcome, everybody. Thanks for being here today. We've got a great event. With me is Professor Leah Litman, who from the University of Michigan, who has written an amazing book, a book that was long overdue in my view. And I want to read the whole title to make sure I get it right, because you had so much fun, I think, in crafting the title. It's called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. One of the great book titles of all time. Welcome, Professor. Thanks for being with us today.
Thanks so much for having me.
So listen, as somebody who lives in the political part of our business and I'm not a lawyer and doesn't live in the legal space, I have felt that the subject matter of your book, which is to sort of put in context what's happened with the Roberts Court, with the sort of the whole trajectory of conservative legal theories, legal theory, is that it is really it's a big and really important story about, and that is sometimes one that we don't necessarily tell very well on the political side. And I'm wondering if you could just sort of give a summary of your book and sort of the big argument you're making in your book, because it's an important one.
Yeah, absolutely. And thank you again for having me. I'm always happy to talk about the Supreme Court and exactly how messed up it is. So this has kind of become my cause celeb. So here I go. So the basic gist of the book is that the Republican-controlled Supreme Court has basically become a mechanism to repackage and launder the political talking points of a Republican Party that has become hell-bent on minority rule and super ginned up on conservative grievance, and how they put that into the law to enable further minority rule and more conservative grievance. And so I guess if I had to focus on just like two aspects of the book for a second, happy to talk about anything else. One would be the extent to which you can actually see the political talking points in the law itself. And the second is how utterly bunk the legal arguments are, because I think that sometimes really gets overlooked when we're just summarizing, the bottom line of these cases or what is happening in court. So I'll start with just one example of how I think the court just completely repackages the Republicans' talking points into the law. So before Donald Trump ever got his grubby little fingers all over the Supreme Court, in 2013, Chief Justice John Roberts authored this decision, Shelby County versus Holder, that dismantled a key part of the Voting Rights Act, the portions that had required certain states with especially bad histories of racial discrimination in voting to get permission from the federal government before they changed their voting laws and policies, basically the former Confederacy. So the Voting Rights Act was really the crown jewel of the civil rights movement. It is what made the United States into a multiracial democracy. It was also opposed by segregationists in the South, Strom Thurmond, as well as others. And when the Voting Rights Act was first really proposed in 1965, you had segregationists like Thurmond opposing it on the ground that it was punitive, unfairly vindictive against the South, and regional discrimination. And this became kind of part of the talking point of the Republican Party throughout the Nixon administration and the Reagan administrations. Those administrations opposed renewing the Voting Rights Act on the ground that, again, elections were for the states, and it was just unfair discrimination and vindictiveness against the former South to force them to get permission before they changed their voting laws. So fast forward, to the Reagan administration, there's a young lawyer in the executive branch. His name is John G. Roberts Jr., and he is tasked with putting together the Reagan administration's talking points about why they didn't want to renew the Voting Rights Act. So he writes memo after memo, talking about how there is no greater intrusion in the states than a system for actually apportioning how states would conduct their elections and select their representatives. And to my mind, all of that context just somehow gets evaporated when in 2013, John Roberts writes this opinion in Shelby County versus Holder that dismantles the preclearance portion of the Voting Rights Act. And why did it do so? Well, it announced that it treated the states unequally in violation of the equal sovereignty principle. Again, this is just straight from the talking points of the segregationists in the 1960s and the Nixon and Reagan administrations when they opposed the Voting Rights Act. They referred to the Voting Rights Act singling out the former Confederacy as disparate treatment, a legal term of art for discrimination. Again, here too, just laundering the talking points of the Republican Party and just announcing that they are part of the Constitution and declaring that the Constitution intended for the states to retain control of the elections. Never mind the whole Reconstruction, Civil War thing. So, that's just one example of how the Republican justices have literally trafficked in the political talking points and political agenda of the Republican Party and papered over it by slapping the label law or doctrine or principle onto it. And I think sometimes that gets lost in people's efforts just to describe, here's what the court did and here's what the court said, rather than talking about, and here's where that came from. So that's
can I just jump in? Is that because I think this is really important, because as somebody who went through Bush v. Gore myself, a few years ago, the track to become a judge or to get to go to the upper reaches of the Republican Party's nominees, many of these people had political backgrounds, right? And when we nominate, Supreme Court justices and high-ranking, they very seldomly have overt political. In fact, we see that as being a negative in many ways when we nominate judges and move them up through the system. John Roberts served in a political administration. John Roberts was a lawyer in Bush v. Gore, was on the Bush campaign in 2000, along with Kavanaugh, right, and Amy Coney Barrett, right?
Yep.
So 3 of the current Supreme Court justices were working on a Republican political campaign, right, 25 years ago. And so the blurring, as you describe, the blurring of the politics and the law was evident by their own backgrounds and the sort of them paying the piper on the political side of the business to show that they were a committed partisan, not just somebody who was committed to something, independent jurisprudence.
Yeah, no, that's exactly right. And that's really one big function that the Federalist Society and other groups like it came to serve, as a credentialing function, and as a way for Republican power brokers to get to know the various lawyers who could be potential judges and to suss out the true believers who they felt confident would do the things that the Republican Party wanted them to do. I mean, when Sam Alito applied for a job in the Reagan administration, he talked about his membership in the Concerned Alumni for Princeton, a group that opposed admitting women to Princeton, a group that published journal articles, opposing access to contraception. He said his interest in constitutional law stemmed from his basically opposition to the Warren Court making the country more democratic. So, he served in the executive branch. Neil Gorsuch served in the executive branch. Brett Kavanaugh served in the executive branch. Clarence Thomas, right, was a political appointee of a Republican administration. They all had connections to Republican politics. So they were well known to the political elites and they knew what they were getting. And, that doesn't just tell Republican politicians what they're going to do because they know what they believe at the time they appointed them. It means they are ensconced in those political circles. So they are continuing to be socialized in what Republican political elites believe. And that allows them to shape their preferences even once they are on the Supreme Court. That's how you get the Republican appointees to do about faces on doctrines about whether administrative agencies, get deference when they're interpreting the statutes that they administer. So the connections to Republican politics are deep and they are intentional and they are, as you say, just not viewed as essential for the Democratic Party. I mean, Justice Jackson, we highlighted she's a former public defender. That's great, right? But this is not someone who was working on Democratic politics to support Democratic partisan aims. I mean, Justice Sotomayor, she was appointed to one of her judgeships by a Republican administration. Again, these are the sort of indicia that can make for great judges. But the point is, we are playing a game that the other side is just fundamentally not interested in.
And you had a
And
second point. You had a second point.
yes. So the second point I wanted to talk about is just like how bunk the legal arguments are that the justices are relying on, because I think sometimes people look at the Supreme Court and they're like, oh gosh, these are lawyers who ascended to the top of their profession. They use these complicated phrases. They must be doing something that I cannot understand. Part of the goal of the book is to convince you that is not the case. So I'm just going to zero in on some examples from the second chapter, which is about LGBTQ equality and the First Amendment. So in the courts, one of the court's most recent cases on LGBT equality, 303 Creative versus Alenis, the court said state of Colorado could not apply its non-discrimination ordinance, which prohibited discrimination on the basis of sexual orientation, to a wedding website designer. So the first thing the court had to kind of come up with is to insist that, well, this wedding website designer, she's not even engaged in discrimination on the basis of sexual orientation. That is, she's not discriminating against people because of who they are, their sexual orientation. She's discriminated against them because of what they do. So what were the people doing in 303 Creative? They sought a wedding website for a same-sex wedding. Guess who often seeks wedding websites for same-sex weddings? Gays, lesbians, bisexuals. But according to Justice Barrett, right, and Justice Gorsuch's majority opinion, well, the baker, the wedding website designer, they would refuse to make a wedding website for a straight couple that wanted to celebrate a same-sex wedding. I don't know how many straight couples are in the market for wedding websites or cakes celebrating same-sex weddings, but my guess is it's pretty vanishingly small. So they make up this whole notion that there's no discrimination on the basis of sexual orientation because some straight couple might want a wedding website celebrating same-sex weddings. And then they insist, but discriminating, right, the real discrimination in the case is against the religious and social conservatives who object to LGBT equality, even though these non-discrimination statutes prohibit everybody from discriminating on the basis of sexual orientation. It's like they truly think that the movement for LGBT civil rights is motivated by religious bigotry and this desire to target, right, religious and social conservatives, rather than, I don't know, the desire for civil rights and the ability to live openly in society. So those are just some examples of the kind of tortured logic and maneuvers they have to engage in order to move the law in their preferred direction. And so again, part of the goal in the book is to empower people to see what the justices are doing, and to convince everyone, like, this is not just the domain of the lawyers, right? These are things that all of us can understand and that all of us should have a voice in.
Well, and there are two things that you've just raised that I want to just reflect on. One is how important it is for Trump to live in a world of invention, right? And to live in a world of fiction and fable. And this sort of crafting of false stories and creating false universes is an essential part of MAGA's project, right? Where, as you pointed out, I mean, it becomes hard. Yeah, I mean, this is sort of the game, right? It's like Fox News itself. I mean, Fox News is a political organization that's pretending to be a news organization, right? The entire thing from top to bottom is completely corrupt and a false fiction every day that they maintain over a long period of time, right? I mean, Fox has been around for 29 years, and the entire, by the way, dogs are encouraged here. I just want to say,
yeah, Stevie,
it's okay. It's okay. You can see
her name is Stevie Nicks.
I have a dog. I have a dog here. So this issue of invention and creation and is very important to the modern MAGA evolution of modern MAGA. And what you're describing is that they had to invent a lot of very creative ways to achieve their political ends that seemed, when you actually really pull it apart, seem on the face of it absurd. And I will go back. I will just tell you, and I didn't mean to bring this up today, but Bush v. Gore came up. I mean, Bush v. Gore itself is like this incredible reach. I mean, the thing I really believe, and I know you may, if I apologize if I haven't read your full book, but Bush v. Gore was sort of, to me, looking back on all this, sort of a significant sort of toe in the water, right?
Mm-hmm.
To them trying to pull off something that was completely outrageous and that they got away with, which is they installed a president into the presidency who didn't clearly win the election. And once they were able to gain power in that way without actually clearly winning an election, I think it created an incentive structure for them to keep going because it was so audacious and outrageous. You know, we had never had a court case in all of American history. I had an advisor during that period who was the dean of the University of Florida Law School who's telling me there's no way we're going to lose this case because there isn't a history of the Supreme Court intervening in a state case like this that was so clearly based on state law. And then if you can just remind everybody sort of how they invented, how they got, what was the workaround around that, if you don't mind. And I know it's horrific to even think about, but it's actually important because it's an early, I think them getting away with that created massive incentive for them to continue to innovate, you know, this new strategy they had. So just remind us about the workaround on Bush v. Gore.
Yeah, so Bush versus Gore has all of the telltale signs of something that just isn't law. So first, the opinion for the court announces, well, this opinion is limited to the present circumstances, i.e., ticket good for one train only. We're just deciding that a Republican is going to be president. There are no actual legal principles in this case or reasoning. So that's one tell. But the second thing is, you know, the theory that you are talking about is this notion of the independent state legislature theory. And the basic principle in our government is when it comes to state law, that's for the states. State courts get to say what state law means. Federal courts get to say what federal law means, right? This is simple enough. And so the Bush campaign legal team and Rehnquist, Scalia, and Thomas said, okay, except when we're dealing with elections, if states, right, expand the right to vote, right, in interpreting their laws, we federal courts get to tell them, no, we don't think your state law means what you think it means. And we might not allow you to enforce state constitutional guarantees that protect the right to vote. So they just made up this principle and pointed to the fact that portions of the Constitution refer to, you know, the legislature shall set the time, place, and manner of elections, or, you know, the number of electors will be decided by, you know, rules made by a state legislature. But nothing gives the federal courts the authority to second guess state courts' interpretations of state laws that are expanding the right to vote. Like, thus far, the only time that federal courts had second guessed state courts' interpretation of federal laws is when state courts were denying people rights, like in the Jim Crow South. Like back when the Alabama Supreme Court was saying, oh, you NAACP, you violated state law, and therefore we get to release all of your members and subject you to horrific risk of violence, you know, torture and death. Then the Supreme Court was like, you know what, you can't muck with state law to deny people federal rights. But the Florida Supreme Court in Bush versus Gore didn't deny anyone their federal rights, right? They just said, let's count everybody's vote. And that was so offensive, right, to the Bush campaign legal team and the three Republican justices. They're like, here's an entire legal theory for why you can't do that.
Well, and what people don't remember, and we'll move on to present day, but that the votes were being counted.
Yes.
So the Supreme Court intervened from votes being counted and made a decision that it was better for votes not to be counted than to be counted, which in a democracy is so on the face of it absurd, right?
Well, and this is another way where the Republican justices just parrot the Republican Party's talking points. But because before Donald Trump was rage tweeting stop the count in 2020, the Republican controlled Supreme Court said, no, literally, Florida, stop the count. You can't do that.
I know. So listen, let's go to present day. We're 6 months in to Trump 2.0. There has been an incredible war in the courts, right? I mean, we've had many inspiring victories and some terrible defeats. I mean, what's your assessment of all this?
I think the lower courts, right, are trying to do their jobs, right? They are trying to enforce the law, and they are not balking, right, at the prospect of an administration that is engaged in brazen, systematic legal violations and flirting with the prospect of defying court orders. The Supreme Court, by contrast, kind of looks at this entire universe and says, you know what the real problem here is? It's lower courts, right, enforcing the law against the administration. So we're going to pause a bunch of those decisions, not tell you why we're doing it, but we're just going to give the Trump administration the go-ahead to implement these policies that lower courts have concluded are illegal, and then limit lower courts' authority in a bunch of ways. So I think 6 months in, it's kind of a Supreme Court and the Trump administration versus the lower courts situation that has emerged thus far. And if there was any question about whether the Supreme Court has, qualms about the Trump administration, I think people should know the court continues to give Donald Trump more and more power, right, to violate more and more laws, even as his administration is engaged in these expansive assertions of executive authority. After their insane, egregious immunity decision, in which they declare the presidents are above the law, at least when it comes to criminal law, they've just doubled down on the theory underlying that decision, which was this unitary executive theory, pushed by, that's one of the fringe theories I talk about in the book, pushed by Republican administrations to give Republican presidents more power. It originated during the Nixon administration when, former Nixon ally Roger Stone claimed that Richard Nixon was the victim of judges, courts, and, juries, trying to enforce the law against him. And that is the theory that this court has embraced to give Donald Trump the power to violate federal laws that restrict his ability to fire, people in the federal government. And so the Republican justices, I think, for the most part, are on board with a lot of what the Trump administration is doing, or at least they see the Trump administration as a vehicle to do a lot of things that they would like to do. And they view the real problem here as the people challenging the Trump administration.
Well, and the point you made is that is that because of the shadow docket, they don't even have to explain their decisions they're making. Can you talk a little bit about that? Because this isn't even fringe legal theory, right? This is like, we don't even know if there is a theory other than Trump asked them to do it, right?
It's the epitome of lawlessness, right? Lawlessness, because we think about courts as being different from, let's say, elected officials, and that they have to explain their decisions, right? They write opinions providing reasons. So what the Supreme Court has done, begun during the first Trump administration, and then just skyrocketed during the second, is the administration will run off to the Supreme Court and say, there's an emergency. We need you to grant what's called a stay, a pause of this lower court decision. And the Supreme Court, by and large, will do that. I think they've granted something like 15 of the administration's last 15 requests. And they oftentimes do so without explanation. That is, they do not deign to explain why the lower courts were wrong, why the administration's actions were possibly lawful. And so they are just giving the administration freebies without having to put in any of the work to explain what it is they're doing. And it is so disrespectful to the lower courts, who then have to continue adjudicating these cases, because all of these cases are arising at preliminary stages. So early stages of a case where a litigant says, okay, well, until the trial, I want you, court, to pause this policy, and then we'll do a trial and we'll figure out whether it's actually finally unlawful. And so they pause these preliminary rulings. The lower courts have no idea what they did wrong, and they have to continue with these cases. It's just an appalling lack of respect for the Supreme Court's role in the federal judicial system.
So 2 final points, and I could talk to you all day, by the way. Just thank you for spending time with us, and I hope you'll come back because I have a lot more questions. But so one of the things that I think is important, and you raised it earlier, is that somehow there's this idea that it's really kind of Alito and Thomas kind of driving the extremism of the court, and that John Roberts has been kind of overwhelmed by them. But this is the Roberts court, and the Roberts court is enabling the things that you're just describing. John Roberts, wrote the landmark Shelby decision, right?
John Roberts is not your friend, liberals.
Yeah. Just expand on that for a minute, if you would.
Okay, let's quickly tick through some of the
Yeah.
decisions this guy has authored. So he is the author of major campaign finance decisions, that dismantled the limits on the aggregate amount, the total amount of money that the super rich could give to all candidates and committees combined. So if you want to know why mega rich individuals like Elon Musk, for example, can donate an unlimited amount of money to an unlimited number of candidates and committees, John Roberts is one reason why. In addition to Shelby County versus Holder, he authored Rucho versus Common Cause. The decision said partisan gerrymandering, the deeply anti-democratic practice where legislatures draw districts to allow themselves to remain in power, even when a majority of voters don't want them to. John Roberts is the guy who said federal courts can't do jack shit about that. John Roberts is the author of the immunity opinion that put Donald Trump above the law. John Roberts has his fingers all over some of the absolute most anti-democratic things the Supreme Court has done. Whether it is campaign finance decisions, political corruption decisions, immunity decisions, or law of democracy cases. It's true he's voted with the Democratic appointees in a handful of cases, but those cases, I think, cannot possibly, overwhelm or undermine the vast number of other ones he has done that do real damage to our constitutional democracy.
It's why I call it the Roberts Court. We need his name, because when the history books, when we get to the other side of this and we write the histories of this period, they aren't written for us, but we write them, I hope, right? There have been a handful of handmaids, right, for this descent into authoritarianism, whatever you want to call it. Roberts, Mitch McConnell, right? These are the people that are going to attempt to sort of put it on the other guys, right? But Roberts has been so central to all of this that and arguably, other than Trump, the most important enabler of this descent into authoritarianism that we're seeing now.
Yeah, I mean, Donald Trump is surely an awful person to be president, but one of the reasons why he is such an awful president is because of all of the enablers around him. McConnell obviously paved the way for the first Trump presidency and then did nothing to really constrain him once he was in office. And John Roberts has done the same. I think John Roberts really paved the way for the second Trump administration in a lot of ways because he slow walked the immunity appeal, assuring there would be no trial on the federal election interference charges before the 2024 election. He gave Donald Trump immunity. He restored him to the ballot, after states tried to disqualify him for his role in January 6th and the Stop the Steal movement. So John Roberts has enabled so much of what the Trump administration is doing, from violating federal laws that attempt to constrain the president's power to unleashing the vast amounts of dark money that helped put Donald Trump in office.
Listen, I think that sometimes when we think of the Republican Party, right, we think of the RNC, but it's really, I joke that like Fox News is really, in some ways now, the Republican Party that's masquerading as a news organization. John Roberts is a partisan masquerading as a judge, right, in the way that we understand it. And the sort of the politicization and the making of partisan things that were in our own minds historically not that way, right, has been one of or the corruption of it, maybe is a better word. And that's what I want to end with, which is, how do we I did an interview that I released today with a congressman named Josh Riley from upstate New York, and he talked about how voters in his district view both parties as being corrupt and Washington as being a corrupt place and everyone's just making money and that they're very distant from them. I think that we, as in the road through, right, and to getting to the other side, however that happens, we're missing a big kind of argument that we need to make to the American people about the corruption of core democratic institutions, about Trump's own plundering of the Treasury and the way he's doing this. We're sort of lacking this sort of big argument about reform, anti-corruption, renewing our democracy. And I just wondered if you could just give us any thoughts about, your contribution to that and how we need to think about this going forward, given what you've written.
Yeah, so I think the Supreme Court basically has to be part of any systematic reform that tries to harden our constitutional democracy against the kind of threats that we have seen over the last decade and that we are likely to see more of in the future. The way I would put it to people is this: imagine that tomorrow Democrats held power in the White House and Congress, and imagine that they enact a renewed Voting Rights Act, a federal law restricting dark money in politics, and a law prohibiting partisan gerrymandering. Do you seriously think John Roberts and his Supreme Court would allow any of those provisions that would undoubtedly improve our constitutional democracy to stand? No. And so, given that they are part of the problem, given that they will not actually allow the country to harden and strengthen its democracy, they have to be part of any sort of reform package. And I think you're absolutely right. I mean, people can see the ways in which the presidency has been corrupted, and the ways in which he is abusing the powers of the office, like dangling pardons right in front of Ghislaine Maxwell and other allies in order to achieve his political ends. Well, the Supreme Court is another institution that has been corrupted. It is an institution that has a long history that people associate with the end of segregation in public schools. But that is the history that Republican justices are capitalizing on and abusing, to advance their right-wing, reactionary, uber billionaire friendly agenda.
Yeah, and I think, and what would that be? I mean, how do we reform the Supreme Court? I mean, I know that you're not the dictator of America and can wave your wand, right? But I mean, what can we imagine would be a kind of reform?
I think it has to include several different things. One is court expansion. You're not going to be able to enact any meaningful Supreme Court reforms with this Supreme Court. There has to be an ethics reform. There has to actually be an enforceable ethics code against the Supreme Court. And again, if Congress enacted that tomorrow, there's no way the Supreme Court would allow that to stand. I mean, Sam Alito basically said as much to the Wall Street Journal in one of the interviews he did. I think you should limit the Supreme Court's authority to strike down laws like a renewed Voting Rights Act or a law restricting, corporate expenditures, unlimited expenditures, and dark money in elections. I think there should also be term limits in order to ensure there aren't sudden changes in the law when a justice might strategically retire or pass away. And in order to force people to pay attention in elections, you are electing someone who's going to appoint at least one justice. So that's the suite of reforms that I would do for the Supreme Court, just to start with.
Okay, listen, I could talk to you all day. Both you and I have other things to do, but you've been amazing today. Thank you listen, I just appreciate the spirit that you're bringing to this, because I do feel that sometimes in our respect for the law, and Democrats as a party are full of lawyers, right? We love lawyers, we respect lawyers, and we respect the law, and we respect rule of law, that we've been hesitant to name names here, that we've been hesitant to talk about the corruption in the judiciary. We've been hesitant to be as honest, frankly, as you were today about what we're really dealing with. And I think the gravity of this is incredible. And we didn't even talk about the fact that McConnell prevented us from appointing a Supreme Court justice in 2016. And I think just like with Bush v. Gore, the Obama people never really figured out how to challenge that, because it was so incredible, right? Like, it was so outside of our democratic traditions. And at some point, we have to stop being so surprised by these things, and to start building into a big strategy for how, we're going to restore the constitutional order that they have tried so hard to tear down. And, you've been a really important teacher to us. And I'm sure that when you go back to teach at school, I don't even know how you teach anymore, because the laws are changing so rapidly in so many ways. Good luck going,
Thank
this
you.
fall in your classes. The poor law students in the middle of the Roberts Court are like having to print whole new textbooks, I'm sure. But anyway, thank you, Leah, so much. And very grateful for you being here. And everybody, check out this book. I haven't read it, but I'm going to now after today's discussion. And thanks everybody for being here.